In Chapter 9, we will learn the meaning of race discrimination, understand that white people can be the victims of race discriminations just as well as black people or any other race, know the importance of treating all workers equally, appreciate the fact that an employer usually invites litigation when it treats people differently. Before forming an opinion on race discrimination, consider both sides by imagining that you are of the other race. Be aware of what constitutes racial harassment. Also be aware to define color discrimination. Be apprised of the parameters of the Reconstruction Era Act. Race discrimination involves treating someone, an applicant or an employee, unfavorably because he or she is of a certain race or because of personal characteristics associated with race, such as hair texture, skin color, or certain facial features. Color discrimination involves treating someone unfavorably because of skin color, complexion, race, or color discrimination can also involve treating someone unfavorably because the person is married to or associated with a person of a certain race or color. Discrimination can occur when the victim and the person who inflicted the discrimination are the same race or color. There are instances when employees discriminate not only against individuals because of their race, but also against those individuals who either associate with their initial targets of discrimination and or advocate for their protection. These individuals, who may or may not be of the same race as those victimized, are entitled to claim race discrimination if their employment is adversely affected. It is unlawful to harass a person because of that person's race or color. Harassment can include, for example, racial slurs, offensive or derogatory remarks about a person's race or color, or the display of racially offensive symbols. Although the law doesn't prohibit simple teasing, offhand comments, or isolated incidents that are not very serious, harassment is illegal when it is so frequent or severe that it creates a hostile or offensive work environment, or when it results in an adverse employment decision, such as the victim being fired or demoted. Following the abolition of slavery, with the passing of the 13th Amendment to the Constitution, in 1866, Congress passed the Reconstruction Era Act. The act provided blacks with the right to make and enforce contracts. As enjoyed by white citizens, the right to make and enforce contracts include employment contracts as well. The Fifth Amendment to the U.S. Constitution provides that no person shall be deprived of life, liberty, or property. Without due process of the law, this amendment, which originally applied only to the federal government, was later applied to the states through the 14th Amendment. The 14th Amendment also guarantees to all persons the equal protection of the laws. Bringing an action under the Constitution does not relieve a party from the statute of limitations under Title VI. The amendments only embellish the validity of the argument against discrimination. If an employee has discriminated at workplace or terminated by the employer due to the race, then he can file a claim with the Equal Opportunity Employment Commission for racial discrimination. It will take several months for this claim to be addressed and for the employee to get a solution, but speaking with a skilled racial discrimination attorney will be the best way to quickly address the wrong that has been done and to get a great solution. Workplace discrimination against employees based on race, gender, or sexual orientation costs businesses an estimated $64 billion annually. A recent report from the Center for American Progress found out the business incur costs in a variety of ways, including through the turnover of about 2 million employees who leave their jobs due to discrimination. Treating employees fairly in the workplace is not just a moral responsibility, it is also necessary to ensure maximum company growth. When an employee is treated unfairly, it results in decreased employee morale. Low morale results in decreased employee productivity. It can also result in high employee turnover. Depending upon the severity of the unfair treatment, an employee may also file a lawsuit against your company. In order to treat people fairly in the workplace, you have to avoid showing favoritism toward one employee over another. Doing so can cause the unfavored employee to resent you. What applies to one employee should apply to all. Do not discriminate based on race, age, religion, disability, sexual orientation, gender, or any other quality. Promote an employee solely based on how qualified he or she is to perform the job, not because of a personal relationship. Otherwise, his or her promotion will appear unfair to other employees who are more qualified to perform the job. Post all job openings for all employees to see instead of verbally telling an employee about an opening. By posting all job openings, employees have an equal opportunity to apply for open positions. Listen to your employee. By listening to your employee, you send the message that her opinion or his feedback is important. If you do all of the talking but never take time to listen, it's unfair. Provide each employee with an employee handbook or rule book to ensure that he or she knows the disciplining rules. Disciplining an employee who is unaware of the rules is unfair. Along that same line, if one employee is disciplined for breaking the rules, all employees should be disciplined for breaking the rules. Recognize and reward each employee for her or his accomplishments, regardless of where she is on the staff hierarchical structure. A case that really stuck out to me was the Lee versus Kmart Corporation. Racial names do not justify slapping a customer. A white customer suspected of shoplifting was escorted to a security area for questioning. The customer's white friend then barged up into the area, cursing at the store employees, one of whom was black. She used the N-word towards the black store employee, who reacted by slapping the verbally abusive customer in the face. The police were called and both customers were arrested. The store then fired the employee for having slapped the customer in violation of its no violence policy and no physical contact with customers policy. The fired employee filed a Title VII race discrimination case, alleging that Kmart was promoting a racially hostile environment and ratifying the hate speech. By firing the victim of harassment, the court ruled against the employee. The customer's behavior was clearly harassing and improper. However, the store took prompt action to have the police remove the offender. The company had policies on how to deal with customers for these situations and how to raise compliance without escalating a situation. Slapping a customer was against policy and not warranted by a verbal situation. The employee's escalation to the physical level was unwarranted and justified discharge. Although many would hope that race discrimination remains a thing of the past, the unfortunate reality is that many still face some discrimination based on their race or national heritage. Employees or employers that practice race discrimination put themselves at risk for heavy fines if any of their employees decide to sue. Many states make it even easier for employees to file complaints against their employers through the special state agency designed to manage such claims. This section contains useful information about bringing a suit or raising a complaint based in racial discrimination, including what kinds of practices might be discriminatory and the procedure for a typical complaint process. Here's a list of some race discrimination applicable laws. The Civil Rights Act of 1964 prohibits racial discrimination in employment. The Equal Credit Opportunity Act prohibits creditors from racial discrimination against credit appliance. The U.S. Code, Title 42, Chapter 21, prohibits racial discrimination in education, employment, access to business and buildings, and federal services, and even more. The Fair Housing Act prohibits racial discrimination in the sale, rental, and financing of housing. The Voting Rights Act of 1965 prohibits racial discrimination in voting practices. The Disaster Relief and Emergency Assistance Act prohibits racial discrimination in relief operations. Many Supreme Court cases have addressed issues of racial discrimination. The nature of a particular incidence of racial discrimination may deeply impact which cases are most relevant. However, there are some cases that have been important in the development of civil rights laws and their enforcement. Some landmark Supreme Court cases involving racial discrimination laws include Cormatt versus the U.S. The laws setting curfews and require the relocation of most Japanese Americans from California was subject to rigid scrutiny due to the curtailment of the civil rights of a single racial group. But the Supreme Court found that the public necessarily, rather than racial antagonism, was the motivation in the laws that were upheld. Shelley versus Kramer was a racially restrictive covenants and property deeds forbidding the transfer of property to minorities were unenforceable. The Brown versus Board Education was a big one. It was racial segregation in business public schools is found to be unconstitutional. Bailey versus Patterson. The interstate and intrastate of transportation facilities may not be racially segregated. Loving versus Virginia. State laws prohibited interracial marriage are unconstitutional. Jones versus Mayor County. The federal law bars all racial discrimination in sale or rental of property.